We're going to continue on the same theme, which is on licensing issues within the right to research. And today we're going to kind of flip and move to the other side of licensing, which is the ability to use that same tool in order to promote more open access to research materials. So to talk about that issue, we have today with us Lucie Guibault. And so Lucie is a professor of intellectual property law. Lucie is also the associate dean and the associate director of the Law and Technology Institute, all of which she means she's incredibly busy. And so I'm so happy to have her with us here today. And here she's presenting some of her work on open access. So Lucie, over to you.
Thank you very much for the very kind introduction. And it's a pleasure for me to be here with all of you today. And I would like indeed to focus today on open content licensing and how it might indeed enable greater text and data mining. I was asked to set up the question, explain the methodology, the analysis, and to draw a conclusion. But I would like to start with the assumption. The assumption that I make is that open content licensing, like Creative Commons licenses, should, in theory, enable TDM research because such licenses allow acts of reproduction and communication to the public. So the assumption is, for example, that the EU Open Science Initiative and other similar initiatives should ultimately result in an increase of the amount of mineable materials. What I mean by this is the question, can open content licenses be applied broadly enough to support TDM research in practice? And you will see that there's this underlying questioning there. That they might not be. First, because, to what subject matter should a license be applied? And how does the law affect the researcher's ability to attach a license to their work? So moving on to the methodology, you will have noticed in the articles that I suggested that I basically follow doctrinal research and comparative legal research, and that the articles really focus on the statutory definition of protectable subject matter under the copyright law and EU sui generis database rights. So my work has been focused for a long time on EU law. So I will highlight the differences between EU law and the law of other parts of the world regarding the protectable subject matter. Also look at the statutory rules of ownership and subsequent transfers of rights and the impact of contractual stipulations. The comparison is between European law, of course, but also French, Dutch, and UK law. Creative Commons licenses, they cover all types of works. And this is key because CC licenses cover, of course, texts, but also any type of work, including films and music and images and compilations of data, as long as those compilations are original enough, either in terms of the selection and arrangements, to be copyright protected. The whole discussion that took place around the drafting of the CC licenses was whether the CC licenses should cover the sui generis database right. So the idea in Europe at the time was that if we license articles, scientific articles, it would be good to also license the underlying databases. And the idea of many affiliates in Europe was that there should be no distinction in the regime between copyright and the sui generis database right. So even if the previous versions of the CC licenses did not cover the database right, some implementation at the local level of CC 2.0, CC 3.0 did cover the database right. I don't know if you're all familiar with the database right. If you're not, I will explain that the European Union has adopted a directive in 1996 that creates a specific IP right to cover databases that demonstrate a substantial investment, either qualitatively or quantitatively, in the collection, verification, and presentation of databases. So the directive was adopted in 96. For the most part, it was implemented by 1998 in all the member states. And it offers basically a two-tier protection for databases. First, copyright. So it confirms the copyright protection of original databases and original compilations, but it also offers this new IP right that covers those databases that are not original, but that show substantial investment. And this is where the members or the affiliates of the Creative Commons licenses in Europe decided that there should be one regime under the CC licenses to cover both rights when dealing with databases. The EU database right is unique. So indeed, some other countries, and I think that South Korea, has a form of database protection, but not many other countries in the world do have that. In the science field, database rights can create barriers because it can entitle the maker of such a database to prevent access and reuse of the content of the database. So this is why, if there is an IP right, there is a good reason to want to apply a CC license to it. The problem is that for a long time, the headquarters of the Creative Commons did not look so favorably on the sui generis database, right? And did not think that it should fall under the scope of the CC licenses, because CC licenses are not meant to cover raw data or compilations of non-protected database. So there was this tension, I would say, between the wish to provide legal certainty for researchers in Europe and the philosophy of not wanting to protect or to cover by licenses objects that are not copyright protected. Well, in the end, I think that the argument to have a single regime under the CC licenses to cover both rights has taken precedence. And so the CC license 4.0 now expressly covers the sui generis database rights, meaning that if you're in the research area and you want to publish your article, you can also publish a database along with that article under the same conditions. I will acknowledge the fact that there might be a slippery slope in attaching license terms to non-protected data, and the slippery slope is that it gives a different signal to users and to members of the public in general to attach a license to non-protected material, because in principle, the non-protected material should be freely available and freely reusable if it's not protected, and there should be no reason to attach a license on it. So the slippery slope is the fact that it might encourage people to appropriate subject matter that would otherwise be non-appropriated because it's not protected. But the counterpart to that is that if that material is not subject to any license, and if it's not clear in the minds of the users that it is not protected, there may be chilling effect on the reuse of such material. So we can hopefully discuss this in the discussion that will follow, how to make sure that, you know, non-protected items are clearly reusable without any conditions if there's no text attached to that to confirm this. So maybe one solution would be, instead of using the typical CC license 4.0, but to attach a CC0 declaration on such non-protected data. So trying to provide legal certainty for owners and users to enable greater use of all the material out there. So that's the idea behind the object. Now, clearly, anything that is copyright protected worldwide is subject to a proper application of the CC licenses. The nuance is when we're dealing with compilations or non-original databases, and this is where the tension arises. So imagine that you're a researcher. Are you able to decide whether to apply a CC license to your article? It depends on whether the institution where the researcher works allows the researcher to retain copyright on their work. And I would say that generally, in most cases, even if researchers are employed by a university, the universities will mainly allow the researcher to retain the copyright on their work. So the researcher could typically decide to publish under open access conditions. In certain cases, the institution may have a say, but usually the collective labor agreement will decide or state that the researcher retains the copyright. The key part is the publisher. So, and this is where we see a difference between the golden road and the green road of open access. But just to make sure that we're all on the same page, the golden road of open access is a direct publication in a fully open access journal, typically under a open CC license. The least restrictive license should be applied for the golden road. The green road is usually that the author will publish directly in a typical commercial journal and will retain only the right to self-archive in a repository. So the article normally follows the normal route of publication by a commercial publisher, but will be submitted for archiving in a repository. This means that for the green road, the author does not typically retain the copyright on the article. Typically, the author will transfer the rights to the publisher. This, therefore, means that institutional repositories cannot apply a CC license to their collection of articles, because there's only this limited, truncated right to just deposit in a repository. It certainly does not give the author the right to attach different terms to the work, to allow a repository to apply CC license and to enable everyone to reuse and communicate to the public under open content licenses. I will note that in Europe, several legislators have adopted a provision in their act, and this is the case of France, the Netherlands, Germany, Italy, and perhaps others as well, that states that any research result that was fully or partially funded by public funding and is published in a periodical publication can be published in a repository. It only allows the author or the researcher to put their article in a repository without infringing anybody's copyright. So it's a certain support for the green road, but it certainly does not go as far as enabling the golden road of open access. So in the absence of specific terms, the question is, can you mine a repository? So ideally, all research results would be licensed under open access to allow TDM. Really, the European Union is perhaps a leader in open science and open access. It really pushes in that direction. And one of the reasons really is that if the European Union finances so much research at the member state level, then the researcher should give access to the research results to everyone of the European Union, all member states, and therefore also worldwide. So there's certainly this European Union idea behind the movement, but also being cognizant that the way forward to solve the major issues in the world comes from open science. So Golden Road would be ideal because it does allow all forms of reproduction and communication to the public that underlie text and data mining activities. The problem lies more on the long tail of publisher catalogs, because that remains subject to the publisher's licensing conditions, and this is certainly not easy. The wealth of information held by publishers is really what I think researchers would love to be able to mine, but publishers' will on their long tail is the main barrier. And the green open access leaves uncertainty, as no CC license can be applied to the collections of repositories. So that's a bit the downside of going green. So the basic answer to the question of the start is, at this time, the use of CC licenses is probably not broad enough to support widespread text and data mining activities, but it's certainly something that we should aim for, in my opinion. So I look forward to the discussions that we'll have, and thank you very much for your attention.